Hi, my name is Layla Shaver. We are going to get started on discussing RIA registration. So, just as a disclosure, we are a law firm, but we're not making any representation about the accuracy of this presentation. And that's because this presentation can be accessed at some point in the future, and the laws can change. So, be sure to check with us about any updates to this presentation. So let's get started with the question I get asked the most. Do I have to register with the state or SEC? So traditionally in the past, small advisors, and those are advisors with less than 25 million in assets under management, are generally regulated by the states unless their state does not have in place a statute that regulates investment advisors. In the past, that state was Wyoming, but since 2017, all states now regulate investment advisors. Mid-sized advisors are those with between 25 and 100 million of assets under management. And those who also have a place of business in New York will have to register in with the SEC. And that's their principal place. So if you're registered, say in Georgia as your primary location, and then you're also registered in New York, that doesn't mean you get to take advantage and register with the SEC. Your principal place of business has to be in New York. For non-US advisors, if you have a principal office and place of business outside the US and you're giving advice to US persons, you must register with the SEC. Multi-state advisors, so if you would have to register in 15 or more states, you are able to register with the SEC. Keep in mind, the SEC will conduct an examination within the first 12 to 24 months of your registration, and they are going to verify that you meet these standards. So they are going to want to see the number of clients you have in each of these states, which justifies you registering with the SEC because you met the multi-state exemption. And then finally, internet advisors. These are advisors who provide advice through an interactive website or completely online, and they may also register with the SEC. So after I get asked, okay, which regulating body do I need to register with? I then get asked, where do I start? So there are a few things that you want to go ahead and get started. You want to form your entity. So whether it's an LLC or a corporation, definitely work with your accountant and tax attorney to identify what's the best structure for you. You want to get your federal tax ID or your EIN for your entity. If you have multiple partners, you want to prepare an operating agreement for your entity. This goes through what each partner is responsible for, what each partner is liable for, and what happens if there's a death or disability of a partner. If you're breaking away, a couple of things you definitely want to review. Any non-solicit and non-compete agreement you're subject to. You want to get a balance due on your promissory notes. That whole balance will become immediately due when you depart that firm. And you also want to review your firm's policies and procedures on client communications. Are you able to connect with them on social media? Are you able to send them a communication when you leave that you are leaving? Those are things you definitely want to get clarification on. Now, once you're ready to get started with the registration process, keep in mind the process is initiated online through the IRD system. And the IRD system is administered by FINRA and is used to submit your registration documents to the states and the SEC. The way you gain access to the IARD system is submitting an application for credentials called Form SAA, or Super Account Administrator. Now, keep in mind, the IARD access is separate from other types of access that you may already have through FINRA. So if you're a broker, for example, you may have a login to your CRD. That is a different logging in platform. So you will still need to fill out and submit Form SAA. So your registration, there are multiple components that have to be completed. So there's part one, a Form ADV, which requires information about your business, ownership, clients, employees, business practice, and any disciplinary events of the advisor or its employees. You have to provide any information about private funds you manage or advise, data about your advisory business. So again, the types of clients you have, um, the number and the different categories they fit in, your business practices that could present conflicts of interest, and any kind of additional information about your outside business activities. So for example, if you are looking to break away and start your own RIA before you're transferring, you're likely to say you have no clients, right? Usually the AUM numbers and client numbers are updated after registration process. But there are opportunities in ADV Part 1 to discuss your business practices and your outside business activities, such as whether or not you sell insurance, whether or not you're a commodities trader or commodity pool operator, whether you manage pooled investment vehicles, whether you are also a registered rep of a broker dealer. ADV 1B is only available for display for firms that are registering as a state registrant. So if you're applying at the SEC level, you will not see ADV Part 1B. In terms of information about state advisor laws and state rules, I always recommend starting with the Nassau website. They've got a really good kind of basic breakdown by state of the fees, of the requirements for registration for each state. But then you definitely want to visit the individual state websites to make sure if there are any updates or changes, they're usually going to be reflected in the state's website itself. Keep in mind for state registered IAs, there's going to be additional disclosure questions on display in Part 1B. And these generally deal with, whether you've ever had a judgment or lien against you, and some questions about previous arbitrations and civil actions. Next, we have Form ADV Part 2. So Form ADV Part 2, most of you are familiar with as the firm brochure. It's actually split into two parts. There's 2A, which is the brochure, and the 2B, which is basically your CV, your curriculum vitae. It gives the background of the advisor. So 2A is being provided to the client. It goes again through your business practices, your strategies, your fees, your conflicts of interest, any disciplinary action. And then the 2B is the brochure supplement that contains the same kinds of information for each individual investment advisor representative and includes their background, business experience, other business activities, and disciplinary history. So the 2A and the 2B have to be delivered to clients annually, and they must be updated annually at a minimum. There are other reasons why you may update your brochure and brochure supplement through the course of the year. But definitely the annual amendment is required to be supplied to your clients annually. Another document that you'll have to have if you're an SEC registrant only, and this is also subject to annual delivery as well, is Form CRF, which is a client or customer relationship summary. It's also known as Form ADV Part 3. So this is an additional 2-page disclosure document that summarizes services, fees, and conflicts of the RA, as well as required regulatory disclosures and questions. Now, one of the areas of concern that comes up for advisors are these disclosure questions in ADV Part 1, right? So have you been bad? If you are registering with the SEC, you can limit your disclosure on an event listed in item 11 to 10 years following the date of the event. If you're registering with the state, you must respond to the questions as posed and may only limit your disclosure to 10 years for certain items in question 11. And for the purposes of calculating that 10-year period, it's the date of the event, which would be the final order, the judgment, decree, or the date any rights of appeal from preliminary orders, judgments, or decrees lapsed. So this really, and again, the questions are broken into criminal, regulatory action, and civil judicial. So really what the regulators are concerned with is, have you previously been convicted of fraud, of theft, of financial exploitation, these kinds of things, liens, bankruptcy, generally things having to deal with finances. And they look at it as, if you have previously been subject to these kinds of actions, it could signify that you have an issue with judgment. And depending on your disclosures, your registration as a firm or as an advisor could be rejected. So definitely make sure you're talking about any disclosures you have on your U4 or any pending actions with your attorney, so you guys can come up with a game plan on how to address the disclosure questions. So what about compliance, right? So you've gotten registered, you've gone through that process. A lot of people are worried about compliance. How many advisors actually like doing their own compliance? I can tell you it's a big round number. I don't know anyone who actually likes doing their own compliance. So a lot of times they're hiring someone in staff, and more often than that, they're outsourcing compliance to a third-party provider. While there has been an explosion in the IA industry of new firms and new advisors coming into the industry, there has not also been an explosion of service providers. So they're becoming harder to find, more expensive, and frankly, there are a lot of providers out there that just really aren't good at providing the service. And unfortunately, we come across a lot of advisors who have been burned or end up in some sort of regulatory action because their previous compliance provider didn't know what the hell they were doing or provided really bad advice. So compliance is definitely something that you should seriously look at and consider. So your basic requirements, you have to designate a chief compliance officer. For most advisors, that's going to be the owner themselves. Sometimes owners will designate an administrative person, another advisor, or another partner as the CCO. You must also adopt policies and procedures that are really going to address the conflicts and other compliance factors in identifying, managing risk exposure, and making sure that the system is going to catch any sort of infractions of the compliance program. You'll also need a code of ethics, and you want some policies and procedures on insider trading. If you're a state registrant, you may be required to provide additional information at the state level. So states may require balance sheets, bonds, audited financials, verification forms. Most states will request a copy of an investment advisory agreement or financial planning agreement to be submitted before review begins. And some states also require that you insert specific code references into your brochure. Now, while you are waiting for your registration to go through, do not add your firm as a current position in your social media accounts. So don't go on LinkedIn, don't go on Facebook and say, hey, I'm a financial advisor at Shaver Asset Management now. No, Shaver Asset Management has not been registered. And the regulators, when they are reviewing your application for registration, are going to go look in the public domain to see what you've posted about the business. If you're holding yourself out as a registered firm when you're not registered, most examiners are going to see that as you are soliciting for new clients. And depending on the de minimis rules in the states you're registering in, you could be violating that state's laws. So as a good rule of thumb, do not add your firm as a current position in your social media accounts until you've spoken to your attorney to get an idea of whether or not that's appropriate. Do not tell your website designer to go live with your website. Again, same reason as the social media accounts. You don't want to be seen as holding yourself out as a registered investment advisor when you're not properly registered. Do not discuss departing with your current clients. You know, if you're subject to a non-solicit or non-compete, if you're breaking away from another firm, you want to have a strategy for your breaking away. You want to have a strategy on how you're notifying your firm and how you're notifying your current clients. You don't want to run afoul of any provisions like a non-solicit or non-compete in your employment contract that would cause some issues because you're telling all your current clients you're leaving. So again, don't discuss it, talk with your attorney, develop a strategy. Do not start soliciting new clients before you're registered, right? So especially if you are registering at the state level, if you're starting the process, let's say in Georgia, but you're soliciting clients in Florida, you don't want to do that because again, back to X1 and 2, you don't want to be seen as holding yourself out before you're properly registered. And then finally, do not discuss your firm with others. Again, we're all about strategy, right? Developing a strategy to leave your firm, get your firm started, and onboard your clients. If you're discussing it with others, it's possible that information is going to get to people you didn't want to know yet. If your firm finds out, they could restrict your access, they could terminate you for cause. Some firms are a bit more retaliatory than others, and they may try to mark up your U5 and say you were terminated for cause, and that you're subject to an investigation because you violated the firm's policies and procedures. Well, that just, is another can of worms that you just opened, because that could trigger an 8210 request from FINRA where they're looking into why you were terminated for cause, what's the investigation, have any investors been harmed? And those are things that are not over in a couple of months. Especially during the pandemic, we saw 8210 requests take over a year, sometimes longer, depending on the significance of the underlying facts. So again, you can really create a lot of issues for yourself simply by discussing your new firm with others. So don't do it. Again, talk to your attorney, develop a strategy. You want to plan ahead. So we're all about strategy here, right? So do have an attorney review your current employment contracts and discuss with you the strategy to break away and onboard your new clients. Do plan on at least 90 to 120 days to get registered. That is from the date you engage a provider to start drafting the documents, to getting the examiners to review it and finalize your registration. Do start your due diligence on finding vendors. Look at your custodians, look at outsourced compliance, look at the different technology you may need, look at TAMPs that you could potentially outsource a lot of these services to, especially for those of you who've come from a bigger corporate structure. You may find that you were paying for a lot of things that you don't really need. If you don't do a lot of financial planning, do you really need financial planning software? If you are dealing with high net worth clients and you only have about 100 clients, do you really need a billing software, or can you do it through an Excel spreadsheet and QuickBooks? So really look at what you need versus what you've been used to having access to. You definitely want to look at your custodians as well, and you want to get clear on what those custodians require. So for example, Schwab is now going to be requiring RAs on their platform to have E&O insurance. So that's going to be an additional cost. You're going to have to find an E&O insurance provider, which actually leads to the next item. We encourage you to get E&O insurance and also get cyber insurance. The number of hacks on financial advisory firms has increased exponentially. And that's because you guys have access to client personally identifiable information, or PII. You have access to their legal names, their account numbers, their social security numbers, their telephone numbers, their date of birth, their current, residential addresses. You have a lot of data that hackers want. And so they're coming after your firm. It's a very good idea to have cyber insurance to protect your firm. And I know this can be very overwhelming, and that's why we are here to answer any questions you'll have. You can call us, text us, email us. We try to make it super easy for you to get in touch with us so that we can discuss your particular needs. We as a firm will create your entity, will register your entity, and will provide ongoing compliance services. And as a law firm, we can help you deal with any of your pending actions, regulatory or criminal or civil actions. And we can also help you address any past U4 disclosures and whether or not they're a good candidate for expungement. But above all, do your due diligence, locate a provider that is going to give you the services you need to make sure you get started up properly, and that will help you figure out and navigate all the things you'll need to get your business running. So, thank you so much for attending our webinar on RIA registration. I look forward to answering your questions.